Well, good evening, everybody, and welcome to our Pupillage Open Evening. Before I hand over to Tom Poole, who runs Pupillage, and the other members of Chambers from whom you will be hearing this evening, I thought I would say a little bit about Three Hare Court, some of which you will have gleaned from our website and elsewhere, but a few things you may not have. How would I describe Three Hare Court in a sentence? A long-established yet forward-thinking, friendly and inclusive barristers' chambers with a reputation for excellence in a number of fields of law. That excellence was, of course, recognized most recently by our award of Chambers of the Year at the LexisNexis Legal Awards 2022, following a year in which members of Chambers appeared in more than 40 cases in the Privy Council and Supreme Court. But when I interviewed for Pupillage in 1990, it was the friendliness by which I was struck above all, both of the clerks and the members of Chambers I met. And that remains as true today as it was then. In part, I suppose that is the result of being a smaller set. We currently number 41, but we will soon be 43. But more importantly, it's also part of the ethos of Three Hare Court. And it is something which solicitors, other members of the bar, pupils and mini-pupils often remark on. And whilst, of course, we have grown somewhat over the 77 years since Chambers was formed and continue to grow incrementally, that friendliness is something of which we are proud and wish to retain. It starts in the clerk's room, where we have a highly experienced and dedicated, friendly and responsive team of clerks and administrative staff, with a well-deserved reputation for their willingness to go the extra mile. And it extends to our members, many of whom give selflessly of their time to various in-house and external initiatives, with a view to supporting the practices and well-being of members and encouraging and helping those who wish to come to the bar. What else would I say marks Three Hare Court out? Undoubtedly, the breadth of the work we do and the opportunity which exists at Three Hare Court to experience different types of work and develop the sort of practice you want without being forced down one route to the exclusion of another. Our members provide a wide range of advocacy and advisory services in the UK and internationally, both at first instance and on appeal, and are ranked by the legal directories in numerous practice areas across a wide range of commercial and common law work. Our clients are similarly diverse, ranging from individuals to multinational corporations, as well as many governments and public authorities. There are, of course, areas in which we do more work than others. The most notable probably being commercial litigation, Privy Council work across the full spectrum of the Judicial Committee's jurisdiction, so criminal, commercial, public law, constitutional cases, among others, personal injury and international travel, including conflicts of law and jurisdiction. But members also practice in many other areas, including international arbitration, civil fraud, financial services, insolvency, public law, inquests and inquiries, employment, professional negligence, property and construction, and several others. And we aim to ensure during pupillage as wide an exposure as possible to the various areas of work in which members practice. I would just mention one more thing, albeit next month there will be a news piece on our website. Namely, that following the departure recently of our marketing manager to pastures new, we have just recruited a director of marketing and business development from a large law firm, about which we are excited. Her role will naturally focus on marketing and BD, but it will also include input in respect of recruitment, retention, equality, diversity, and inclusion, all of which we see as integral to modern business development. With that brief introduction, I'm now going to hand over to Tom, who's going to tell you more about what to expect from this evening, about the application process, the structure and content of pupillage, how we make decisions about tenancy, and importantly, the support we provide to new tenants. Tom, can I hand over to you?
Thank you, Howard, and good evening, everyone, and thank you for joining our Pupillage Open evening. The aim of this evening is to give prospective pupils an opportunity to learn more about Three Hare Court, what perhaps sets us apart from other civil commercial sets, and importantly, to discuss and hopefully demystify the journey from pupillage application all the way through to pupillage, tenancy, and beyond. So, what can you expect of this evening? Well, as head of pupillage, I'm going to kick off by explaining, as Howard's just said, the application process, what pupillage at Three Hare Court looks like, how we make decisions about tenancy, and then the support we provide our new tenants. I'm going to be assisted by Nick Lee, who is one of our current pupils, and will be giving some invaluable tips on how to make a good pupillage application. I'm also going to introduce you to Guy Mitchell, who is our Chambers manager, without whom pupillage recruitment and delivery would not run as smoothly as it does. And Guy is usually the first point of contact for any pupillage queries, and I'm sure we'll pick up on anything that I've inadvertently overlooked. You'll then hear from Chloe Shuffrey, who is head of Equality, Diversity and Inclusivity Committee in Chambers. And Chloe is going to tell you about some of the many things we're doing to promote EDI in Chambers. And then comes arguably the most important part of the evening, where you'll hear from some of our junior tenants and pupils about their experiences of training and practice at Three Hare Court. We'll then attempt to answer some questions before we conclude. Just a point on questions, we've already had some questions submitted, but if anyone watching and listening has a question that they would like answered, do feel free to use the Q&A function, and we will do our best to answer as many of those questions as possible. If we don't manage to get through those questions, you can always follow up by emailing our dedicated pupillage email address, details of which I will make sure is put up on the final slide. So, why Three Hare Court? Well, this question will hopefully have been answered by the time you've heard from all of our speakers this evening. But for my part, there are three aspects which Howard has already touched upon in his introduction. The first is the quality and breadth of work Chambers has to offer, and that as a pupil, you will be immersed in from the very start. As I'll explain a bit later on, one way we seek to achieve this is by having our pupils work with at least 6 supervisors during their pupillage year, and thereby experience 6 different practices, which we think is a unique opportunity. The second aspect is the emphasis we place in Chambers on advocacy, which is reflected in our advocacy training program, and the fact that all of our pupils have a fully practicing second 6, which sees them regularly in court week in, week out. And the third, and some might say the most important, is the fact that Chambers is, as Howard has said, a friendly set with a strong community feel. And I say that as someone that joined Chambers as a pupil some 22 years ago. And although personnel have naturally changed over the years, friendliness and a sense of collegiality is something that Chambers has always managed to retain and is, I think, extremely important. And I'm sure you'll hear from some of the juniors later, and they will hopefully confirm that. But I know from my part, there are plenty of spontaneous and organised informal get-togethers within Chambers. So pupils in Chambers have plenty of opportunities to meet and get to know everyone. Applying for pupillage then at Three Hare Court. All applications for pupillage have to be made through the Pupillage Gateway, which, as I'm sure everyone knows, opened on the 4th of January and will close at midnight on the 8th of February, so just under 3 weeks' time. What are we looking for? The purpose of our selection process in Chambers is to identify pupils who we anticipate will be outstanding candidates to join Chambers as tenants and strengthen our areas of practice. We're therefore looking for candidates with a strong academic background, clarity of expression, strong people skills, and the commitment and energy to succeed in the competitive world of the modern bar. Ultimately, we're looking for strength across the board. It's a bit like top trumps. So if perhaps you might feel your interpersonal skills let you down, you can make up for that with strengths in other areas. Similarly, although we talk about a strong academic record, we will take into account substantial professional experience where an applicant may not, for example, have achieved the academic grades they might have hoped for. Now, Chloe in a moment is going to talk about equality and diversity in more detail, but in terms of recruitment, it is right to say that Chambers is committed to diversity at the bar and ensuring that our pupils are selected from a wide range of backgrounds and experience. And it's for this reason we especially encourage and welcome applications from women, people with Black, Asian and ethnic minority backgrounds, those with disabilities, and those who are LGBTQ, as well as those from other groups that tend to be underrepresented in the legal profession. Chambers' commitment to equality and diversity is reflected in all of our recruitment decisions, but what that means for pupillage applications is, firstly, all applications are blind marked at the sifting stage. So only the candidate's number is visible to Chambers. Chambers therefore does not know any of the candidate's personal information, such as sex, age, ethnicity, or other protected characteristics. All applications are assessed and scored strictly by reference to defined objective and fair criteria. And all members of Chambers that are involved in the selection process, which includes the sifting of applications, have received the appropriate level of training in fair recruitment and selection processes. So once the applications have been assessed and marked, we shortlist the 20 highest scoring candidates who we invite for interview. This year, the first round interviews will take place in mid-March. They will be remote interviews, as our experience over the last few years is that remote interviews work particularly well. They allow us to see more people than we might otherwise be able to if holding in-person interviews. They also relieve some of the pressure on candidates who might not be based in London or might not find it that easy to travel to see us in the Temple. Moreover, as remote advocacy is now much more common and certainly here to stay, remote interviews give us an opportunity to assess how candidates are able to present themselves and interact over a remote platform. I interview all first round candidates along with 2 or 3 other members of Chambers. Members of the interview panel are selected having regard to the need for maintaining an appropriately diverse panel, diverse in terms of both characteristics, but also practice areas. And as already mentioned, each member of the panel is trained in fair selection methods. First round interviews generally last between 15 to 20 minutes. Candidates are asked a range of both competency questions and questions about their application. As we've set out on the slide, the questions asked are looking for evidence of 5 things: intellectual ability, legal knowledge and practical analytical skills, oral skills and the ability to relate to others, initiative, application and motivation, and reasons for applying to Chambers. Candidates are then marked against those 5 competencies, and the 10 best performing candidates are invited for a second round interview. Second round interviews take place in person in Chambers, unless alternative arrangements need to be made. They will probably take place towards the end of March, beginning of April this year. There's a slightly larger interview panel for second round interviews, consisting of 4 or 5 members of Chambers. For consistency and fairness, I sit on the second round panel, but all other panel members will not have been involved in the first round interviews. It's not the purpose of the second round interview to revisit territory that's been covered in the first interview. Rather, it's designed to provide an opportunity for those with the greatest potential to shine. Second round interviews generally last about 30 minutes and consist of an advocacy exercise followed by some further competency-based questions. Candidates are given the materials they need for the advocacy exercise in advance and will be expected to spend about half the interview undertaking the advocacy exercise, with one of the interview panel playing the role of the judge. As with first round interviews, candidates are marked against objective criteria. The 3 criteria at second round interviews being oral skills presentation, practical analytical skills, logic and reasoning, and interest in career at the bar and Chambers work. At the completion of second round interviews, all candidates' scores from both first and second rounds are combined, and the 2 highest scoring candidates are made offers of pupillage. Before I go on to talk about pupillage at Three Hare Court and give everyone a break really from listening to me, I'm going to hand over to Nick, who's going to give some advice on how to make a good pupillage application.
Thank you very much, Tom. Good evening, everyone. I recall vividly being in your shoes a few years ago, attending open evenings like this and applying for pupillage. I want to offer 5 pieces of advice in a few minutes that remain for me. I was recently asked to do this in 1 minute, so I'm relieved to have a little more time to do so. My 5 pieces of advice are as follows: preparation, structure, evidence, style, and proofread. And I'll take those in turn. In terms of preparation, my advice would be that you research very clearly what it is that any chambers that you're applying to do, the areas of law. And of course, this advice applies to any chambers, not just Three Hare Court. You've already heard from Tom and Howard as to the areas that we practice here at Three Hare Court, but it's important that you do your research for each chambers of which you apply to. Further, I recommend that you look at the criteria by which your application will be assessed. And I would suggest that you copy and paste the criteria, which could be found on any chamber's website, into a separate Word document and work alongside those criteria when drafting your application form, so you can point out on your form where you've met that criteria. The second piece of advice I have is structure. This is really important. When it comes to general stock questions like, why do you want to become a barrister? Why are you applying to these chambers, to Three Hare Court? What areas of law are you interested in practicing in? I would recommend a few distinct paragraphs setting out clearly in answer to those questions. The rule of 3, for whatever reason in life, often works very well, and it's a technique that I employed during my applications. But when it comes to competency-based questions, those such as describe a time when you've worked to a tight deadline, or describe a time when you've had to argue a particular point of view, you may want to adopt the STAR technique. This is a popular technique, which I'm sure you're familiar with. Situation, task, action, result. You set up with the situation that you were involved in. You explain the task that you had to address, the action you took in addressing that task, and the result, crucially, from your action. My third piece of advice is evidence, and this is important. That you display a range of evidence across your application form and do not rely solely on a single piece of evidence for each question. You need to show tangible illustrations of your interest and your motivation in this career. And that means you show, not tell. It's all well and good telling the reader of your application that you're interested, but they want to be shown what you've done to demonstrate that interest. Fourthly, style. And this is also a crucial point in writing a good pupillage application. I suggest that you adopt a clear and concise writing style. It's the time to be simple and impactful, not poetic. A pupillage application form is not there designed to see how well you understand the English language, but rather for you to put across in a few hundred words often why you have the motivation, skills and experience to succeed in this career. And therefore, I suggest avoiding a narrative style of application writing and rather treat it like a piece of written advocacy. What 2 or 3 arguments are you making that actually demonstrate your interests? So you set out a simple, well-structured and supported with evidence set of paragraphs, and that will be a much more effective written application. And finally, the obvious point of departure is proofread. Very important that you avoid any grammatical or spelling errors in your applications. And I would recommend something that I did, sharing your applications with a layperson who's not familiar with the law, and see what they make of your writing and whether or not it comes across as persuasive to them. So without further ado, I pass back on to Tom to continue his discussion of the pupillage process.
Thank you very much, Nick. Some excellent tips there, which if everyone is going to follow, is going to make it even harder for us to compile a shortlist for first round interviews, I fear. So pupillage at Three Hare Court. Let's deal with the nuts and bolts first, namely number of pupillages and the award. We offer 2 pupillages every year. As I mentioned when talking about recruitment, our selection process is designed to identify pupils who we anticipate will make outstanding tenants. Pupils are therefore not in competition with each other. Our aim is to offer all of our pupils tenancy at the end of their pupillage. And in this regard, we have an excellent track record of doing so, dating back many years. The current pupillage award is £62,500. This usually takes the form of £42,500 in the first 6 months, and thereafter a guaranteed £20,000 for the second 6 months, plus receipts for work done in your second 6. There is, however, flexibility as to how the award can be structured. Something not mentioned on the slide is that up to £10,000 of the award may be drawn down in advance during the BPTC. And again, there's flexibility in that regard. As well as the pupillage award, Chambers also provides additional financial support for pupils so as to enhance the affordability of training. So, for example, pupils' reasonable travel expenses will be covered by Chambers when travelling with supervisors to and from court or a conference out of Chambers. Turning then to what you can expect of pupillage, starting at day 1 and the all-important pupil supervisors. On your first day of pupillage at Three Hare Court, you'll normally be met by myself and Guy, who you will hear from in a moment. Guy will spend most of the day going through everything you need to know, from setting up with Chambers IT to the more important things like where the nearest coffee machine is. Guy will also walk you around Chambers, introduce you to the clerks and any members of Chambers that are around and not in court. You will then be introduced to your pupil supervisor, who will be responsible for your training and supervision for the first 6 to 8 weeks of pupillage. At Three Hare Court, we believe that pupils get the most out of pupillage when they are in regular daily contact with their supervisor, which allows pupils to learn osmotically. It's for that reason that we encourage pupils to base themselves in their supervisor's room in Chambers, where they will have their own desk. Where this isn't possible, we have a number of hot desks, 2 of which are prioritised for our pupils to use. Other flexible working arrangements can also be arranged, and we encourage all pupils and supervisors to have a conversation at the start of each new seat to discuss working arrangements and expectations. As I mentioned earlier, pupils then change supervisors every 6 to 8 weeks. That means that in a typical year, pupils should have spent time with 6 or possibly even 7 different supervisors. The reason for this is that we think it important that pupils experience the widest range of work in Chambers, and what better way of achieving this than having a variety of pupil supervisors. Our current supervisors are listed on the slide, and as you will see, they cover the whole gamut of work in Chambers. Our supervisors also range in seniority, which ensures that our pupils are not only seeing a wide variety of work, but are also seeing how practices can differ at different stages of a career at the bar. How is pupillage structured? Well, at Three Hare Court, we divide pupillage into the conventional 2 6-month periods, so your first 6 and your second 6. During your first 6, pupils usually sit with at least 3 supervisors, and the focus during that period is on doing written work for those supervisors. For example, drafting pleadings, opinions, skeleton arguments, research notes. Pupils will also attend conferences with their supervisors and shadow them in court. Supervisors review all written work produced by pupils and provide detailed feedback, allowing pupils to identify areas that need improvement and ensure they're doing everything to meet the selection criteria for tenancy, which I shall come on to in a moment. Although pupils will spend the most one-to-one time with their supervisors during their first 6, pupils are encouraged to undertake work for other members of Chambers and to get to know as many members of Chambers as possible. To this end, if someone in Chambers is involved in an appeal in the Supreme Court or the Privy Council, or has an interesting trial, pupils will be offered the opportunity of shadowing that person. And in those circumstances, pupils will be given copies of relevant documents in the case. So, for example, skeleton arguments, so that they can understand what's going on, and will be given the opportunity to discuss the case with the member of Chambers involved, so as to make the most of the learning opportunity. As pupils approach the end of their first six, they're encouraged to go to court with the more junior members of chambers in order to gain relevant experience before they start taking their own cases. In the second six, our pupils learn to cope with handling a busy practice from the start, and usually find that they gain a significantly higher level of advocacy experience than their friends and peers in other similar chambers. On average, our pupils can expect to be in court at least 2 days or even 3 days out of 5 for large parts of their second six. As well as court appearances, pupils in their second six can expect to have their own paperwork, as well as continuing to undertake written work for their supervisors. Pupils throughout pupillage, so both first and second six pupils, will be encouraged to contribute to news articles on Chambers' website and social media platforms, and also to attend networking events so as to forge their own relationships and ensure their own professional development. Chambers also organises a series of advocacy exercises throughout the pupillage year, culminating in a mock trial towards the end of the second six. The advocacy exercises are based on the same case, so pupils get to see a case from start to finish. And those exercises are observed by members of Chambers, and feedback usually given by the advocacy trainer who runs the session, which is usually a silk or a senior member of Chambers. Moving on to feedback and assessment. As already mentioned, pupils are given written feedback for every piece of written work they do. And if work is done for another member of Chambers, that member is asked to send a copy of the feedback to the current supervisor so it can feed into the pupil's formal assessment. As well as feedback on individual pieces of work and informal day-to-day discussions, pupils have monthly appraisals with their supervisors and a formal assessment at the end of each pupillage seat. Monthly appraisals involve a review of work undertaken, a discussion about any feedback received from other members of Chambers, and any future action or development required. At these monthly appraisals, pupils are actively encouraged to raise any questions they may have with their supervisors about their progress and training in general. The formal assessment involves the pupil supervisor undertaking a review of the work produced by the pupil over the course of the seat and completing an assessment record in which the pupil is graded. Our grading is out of a maximum of 4 marks. A mark of 1 means that the standard has not been met. A mark of 2 means that the standard has partially been met. And a mark of 3 means that the standard has been fully met. And a mark of 4 means the standard has been exceeded. Pupils are graded against Chambers' 5 key selection criteria, which are set out on the slide. First, intellectual ability and legal professional skills. Second, impact and advocacy. Third, interpersonal skills. Fourth, motivation. And fifth, temperament. In addition to grading their pupil in the assessment record, pupil supervisors will provide concise and hopefully constructive comments under each criterion. Pupils are then given the opportunity to discuss their assessment record with their supervisor and to record any comments that they might have on the document. We think through this combination of informal discussion, monthly appraisals, and formal assessments, we provide pupils with consistent and transparent guidance on their progress and hopefully maximize their potential to improve during the pupillage training. Turn next then to the end of pupillage and the tenancy decision. Tenancy decisions at Three Headquarters are normally taken after about 9 months of pupillage. So that means the middle to end of July of the pupillage year. The decisions are taken by Chambers as a whole and are based principally on the considered views of the pupil supervisors, including the pupil supervisors' conclusions as captured in the formal assessments completed at the end of each pupillage seat. It therefore follows that what Chambers is looking for is someone who has consistently met or indeed exceeded the required standard by reference to our selection criteria. Generally speaking, this will be someone who has consistently demonstrated the ability to identify, analyse and argue salient points, consistently produced excellent written work, shown that they can cope under pressure, and demonstrated that they have what it takes to develop a strong practice. And as I mentioned earlier, we have an excellent track record for recruiting our pupils, which is obviously testament to their qualities, but also the training that we provide. Now, before I hand over to Guy to mention anything that I have missed, I should mention a few things that we do in Chambers to support our junior tenants as they make the transition from pupillage to practice. And I will keep this brief, as you're going to be hearing from our junior tenants shortly, and they can speak for themselves. One of the key things that we do is offer a very favourable rent structure for the first few years of practice. We also operate a mentor scheme for junior tenants, whereby a junior tenant is allocated a senior member of Chambers who is available to offer advice and guidance regarding practice development in a mentoring role. We also ensure that regular practice development meetings take place between members of Chambers and the clerks. The purpose of those meetings is to enable discussion of work allocation, work opportunity, marketing, networking, opportunities, and to also set objectives. And we understand that these meetings can be particularly important when you're starting out at the bar. And it's for this reason that we try and ensure that junior tenants have practice development meetings once every quarter. Well, I think you've heard from me for far too long. I'm therefore going to ask Guy to introduce himself and just mention anything that I should have done before I then hand over to Chloe to talk to you about EDI in Chambers.
Thanks.
Guy.
So I'm the Chambers manager, as Tom's already pointed out, and I'm here basically along with my colleagues to answer any questions during the pupillage process. We appreciate the time and effort you put into applying to Chambers, whether it's through a mini pupillage or pupillage. And as I say, we're just here to answer any questions and make the process go as smooth as possible for you. Tom's put up on the screen. You can also see details about our mini pupillage and the Chambers pupillage process on our website. So do pop onto the 3 Head Court website. And for any information and questions you can put to us there. Thanks.
Great. Thank you very much, Guy. Now, without further ado, I'll ask Chloe to speak to us about EDI in Chambers. Over to you, Chloe.
Thank you, Tom. Good evening, everyone. As Tom mentioned earlier on, I am Chambers Equality and Diversity Officer. So I have oversight and responsibility for EDI policies and other matters, and I'm generally the first point of contact for anyone in Chambers, be it a member of Chambers, a member of staff, or a pupil who wants to raise any EDI related issues or has any EDI related concerns. Chambers also has a dedicated gender equality and diversity representative who is currently Catherine Bailey, who's a junior tenant in Chambers. And the two of us, together with 6 other members of Chambers, comprise the EDI committee. The EDI committee has been particularly proactive over the past 2 or 3 years. We meet once a month to work on updating policies, discussing how we can best implement those policies, and discussing also what other initiatives and programs Chambers might participate in, as well as dealing with any other ad hoc EDI issues that arise. One of our main priorities over the past couple of years has been the development and implementation of a brand new equal access to and fair allocation of work policy, which is mentioned in the first bullet point on the slide there. That's a policy which is designed to ensure that work opportunities that come into Chambers are distributed fairly as between members, and that includes both unallocated work that comes in from solicitors, namely where the solicitor has not themselves specified a particular barrister they would like to undertake the work. That work has to be allocated fairly as between members, as well as opportunities that members may present to each other. For example, where a silk needs to bring in a junior on a case, the process by which they select that junior must comply with the policy. Compliance with the policy is kept under review by me as the Equality and Diversity Officer, as well as Catherine as the Gender Equality and Diversity Representative. So we'll scrutinise and crunch the data on a quarterly basis, and we will raise in the first instance with the EDI committee any concerns or issues that we have in terms of compliance with the policy, which would subsequently be passed up to the management committee if there were any issues that required addressing or the amendment of any policy. And the clerks receive dedicated fair allocation of work training so that they understand exactly what is required of them, as well as general EDI training, which is received externally. So someone from the Bar Council comes into Chambers to provide that training. Another matter that we've been working on recently is the drawing up of a race action plan, and that is partly in response to the sadly quite woeful statistics in the Bar Council's recent Race at the Bar report, of which some of you may be aware. Those from ethnic minority backgrounds sadly remain significantly underrepresented at the bar, and our own race action plan has, amongst many other things, set fairly ambitious targets in terms of at the outset attracting applications from those from ethnic minority backgrounds. So as Tom said earlier, we very much encourage applications from those from ethnic minority backgrounds, as well as from others from underrepresented groups at the bar. This is very much a living and evolving document where we hope to keep increasing those targets over the years, and it will remain one of the EDI committee's priorities. We've also signed up to the Women in Law Pledge. That was created by the Bar Council, the Law Society, and the Chartered Institute of Legal Executives, and it's designed to tackle the issue of gender equality across the legal profession as a whole. We have a Women in Law Pledge action plan, to which there's a link on our E&D page on our website. And that has to some extent informed the drafting of our various policies. So for example, in our fair allocation of work policy, we ensure that those coming back from a period of parental leave of 3 months or longer are prioritised for a set period in terms of being allocated unallocated work, in order to assist them in rebuilding their practice. And that's, of course, an issue that disproportionately affects women, who tend to take longer periods of parental leave than men, but not always and not necessarily. In addition to our policies and action plans, Chambers participates in many initiatives and programmes that are aimed at promoting equality and diversity at the bar. And I've mentioned on the slides a few examples. So Free Bar, BLAG, which stands for Bar, Lesbian and Gay Group, and the LGBT Plus Network, which are organisations providing support networks for LGBTQ plus persons at the bar. And we also are participate in the 10KBI 10,000 Black Interns programme, which offers paid internships to those from Black African, Black Caribbean and Black British backgrounds. So Chambers hosts an intern annually from the 10KBI initiative. The Social Mobility Foundation, we're a partner of theirs and offer work experience placements to those from socioeconomically disadvantaged backgrounds. And we're also a partner and sponsor of Bridging the Bar, which is a charity that seeks to increase equality of access to opportunities at the bar across all underrepresented groups. Diversity data monitoring, we have a dedicated diversity data officer, who's a different person from me, who is responsible not only for collecting and analysing diversity data of members and staff of Chambers, but also diversity data of applicants for pupillage and mini pupillage, and its analysis of that data, which is crucial to informing our policies and action plans and setting appropriate targets. Finally, I just wanted to mention, although it's not technically an EDI issue, but we are one of the founding signatories to the Greener Litigation Pledge, which I think was ultimately conceived by Mishcon de Reya, and it's a commitment to taking active steps to reduce the environmental impact of litigation. So, for example, promoting the use of electronic rather than hard copy bundles, of remotely held hearings or remote participation of witnesses where appropriate to reduce travel and the carbon footprint of litigation. So that's just another example of how Chambers strives to be proactive rather than simply reactive when it comes to our wider role in society, or what we perceive to be our wider role in society as a set of barristers' chambers. That's just a very quick overview of Chambers' EDI activities and commitments. There's more information on our E&D webpage, on our website, but I think I'm now handing back over to Tom.
Thank you very much, Chloe, for running through some of the initiatives within Chambers promoting EDI. And as Chloe said, you can find out a lot more information as well on our dedicated EDI page of our website. I'm now going to hand over to our pupils and junior tenants for them to give you their personal insights. And I know from one of the questions that's been asked is about practice areas that pupils likely will be undertaking during their second six. And I'm sure that that will be sort of answered by some of the talks you'll hear in a moment. I'll just briefly introduce who you're going to hear from. You're going to hear from Nick first. Nick, as I told you earlier, is one of our current pupils. He started pupillage with us in October last year, and so is a little over halfway through his first six. You'll then hear from Anna, who started pupillage with us in October 2021 and is due to become a tenant next month, having had a period of maternity leave during pupillage, hence the perhaps rather unusual description of her as a junior tenant in waiting. You'll then hear from Claire, who started pupillage alongside Anna in October 2021 and became a tenant last October on successful completion of her pupillage. And last but not least, you'll be hearing from Adam, who had the privilege, although he may say the misfortune, of being my last pupil, and he completed his pupillage and was taken on as a tenant in October 2021, and so has just over a year of practice under his belt. So if I can hand over to Nick first of all, please.
Thank you, Tom. So I want to speak about two aspects of my experience so far as a pupil at Three Hare Court, the work and the culture. And I should just headline that my experience so far has been overwhelmingly positive. So on the work front, I think it's fair to say, and you saw the slides earlier, that the work is incredibly varied. And that is true of what I've seen so far. I've been with two supervisors, and I'm shortly going to be moving into my third seat with Catherine Deal KC. And I've seen work from international travel cases, personal injury, property, public law, company law, insolvency law, and other forms of commercial litigation. So just in the space of 3 months, that sheer variety. And something that I've noticed is that a lot of the work has a discernibly international dimension. And that's a particular interest to me, where cases arise from different common law jurisdictions across the world, or events leading to accidents in international settings. I've also been able to visit courts of different levels, from appellate advocacy, trials, and also different levels of hearings. And I've been lucky enough to attend mediation as well. I think the other thing I'd mention in terms of the work is that there is a discernible emphasis on the skills that you develop as a pupil. I've done everything really that I suppose that the job at the sort of second, sixth stage has to offer, from drafting to advice, to research notes for supervisors, drafting counter schedules, even draft orders after hearings. And I know that that's not the case at every chambers. I've got a number of friends at different chambers who have only recently moved on to writing advices for the first time. So you do immediately do a range of written work right from the go in Three Hare Court. And also, I should point out that you do get helpful feedback along the way, effectively with each exercise that you do, has been my experience, but also those monthly appraisals and final feedback sessions at the end of each seat has been really helpful. And secondly, I wanted to talk about the culture. And this is something that's particularly important to me. I've always wanted to be based somewhere where I felt supported, and there is a collegiate and friendly culture within which I work. And that's certainly the case here at Three Hare Court. Immediately from being a pupil, only a few weeks in, I attended the Chambers' 75th anniversary, which really was the 77th, delayed by COVID. But that was an amazing opportunity for me to meet virtually every member of Chambers, and also a number of clients that were invited to that event, in fact, hundreds of clients. So a great opportunity for me to put myself out there as well to people who I hope that I can develop a relationship with in the future. And then finally, I would say as well that Chambers is composed not just of its barrister members, but also its clerking team and its administrative staff. And I've got on already incredibly well with all of those that I've met. Lucky enough to have been to different events with them, including a football fixture, which took place between us and a law firm back in November, which we won narrowly. But I've really enjoyed being a part of Chambers culture, and it has been honestly one of a very supportive experiences, and I hope that will continue going forward. So I'm now going to pass over to Anna, who recently completed her pupillage.
Thank you, Nick. As Tom mentioned, I had a slightly unusual start to my pupillage as I was pregnant with my second son. And I was naturally quite apprehensive as to how this would be received by my new chambers. But truly, I couldn't have asked for a warmer reception. And this was a very good sign to me. So in the brief time I have, I'm going to touch on, firstly, 2 memorable reflections from my first 6, and then the transaction to the second 6, and then towards tenancy. So the 2 memorable reflections during my first 6 was first one, which is about a month into my pupillage, when Claire and I, who you'll hear from shortly, had the privilege of watching Howard and Tom in the Privy Council. And it was for a case concerning whether the mandatory death sentence in Trinidad and Tobago was unconstitutional. I remember sitting there thinking, how on earth did I land a Chambers that does just such exciting work? There were 11 committee members of the Privy Council, and all of whom were Supreme Court judges determining this case. So that was very exciting. The second most memorable reflection, I think, was at the end of my second 6, the end of my first 6, where Nick is, and remember looking back and seeing the extent to which I had rewired my brain to think more like a barrister, because you're constantly exposed to, you know, reading papers and pleadings. And by the end of that second 6, you surprise yourself as your ability to draft or narrow the issues in a large bundle. And this was really rewarding to me, and really sets you up for your transition to your second 6. And naturally, at the start of your second 6, you do feel quite a little bit daunted by what's expected of you. You're slightly in the Wild West, but I actually found it quite liberating, because you have to take charge over your own matters, because no one else is going to be there in the courtroom to say, oh, you do this now. So you really get a quite strong sense of, okay, I'm going to explore all the issues here and make sure I'm on top of it. And you rely on yourself, and that is quite a powerful feeling. And also you start to get paid, which is also welcome. And you learn the craft of advocacy, which is something you really can only improve through practice. And as has been discussed, we're so lucky to be exposed at such a junior end to regular advocacy. We often do road traffic accidents or applications or flight travel claims, and quite regularly. So you do build up those skills and become more confident over time. The transition to tenancy, I'm technically not there till about 2 weeks. However, I've certainly noticed that there's a change in gears as you start to build relationships with solicitors, and you start to build your own brand and practice. You start to narrow ever so slightly what work you want to do and what you don't want to do, and you're encouraged through your clerks and also through other members of Chambers to build your own practice in the way that you want. So to conclude, and really just to echo what Howard and Tom have said, Freehair Court is truly a friendly set, and the members, the administrative staff, the clerks, they're really supportive and open-minded. The members and the clerks, they want to ensure that pupils enjoy their time and find the work for them that actually interests them. So it's important not to forget that. So please come, it's a wonderful Chambers, and do send through any questions you have. I'm going to pass on now to Claire.
Thank you, Anna. Good evening, everyone. And as Tom said, I'm the newest junior tenant in Chambers, having started tenancy in October last year. So I'm about 4 months in, and I'm going to really share a bit about my experiences transitioning from pupillage and second 6 into tenancy. So this transition definitely seems daunting, and I personally was really nervous for this. But in fact, there's 2 main reasons that on reflection, I really needn't have been as apprehensive as I was about this transition. And firstly, I'd say that this is because second 6 prepares you very well for what you're going to encounter in the first few months of tenancy. And I know that Nick and Anna have touched on this, but in fact, you'll largely be doing the same sorts of small claims and fast track claims that you've been getting used to during your second six in your tenancy. And you'll also be dealing with a lot of the same instructing solicitors and claims handlers that you've already done some work for towards the end of second six. And there are points that things really just start to click, and that's a really satisfying part of the first few months of tenancy. So content-wise, it's very manageable given the focus on practical training that pupillage at Three Hare Court does uniquely give you. But secondly, and on a more human level, the transition can be a daunting prospect because in terms of terminology, you're going from being supervised to really being on your own. But in reality, I didn't feel like I was on my own at all. One of the best features of Three Hare Court, and I know that my fellow members have already touched on this, but is how genuinely lovely and friendly everyone is, from the staff to the members as well. I must admit, and being fully honest, as someone who doesn't come from a legal family, I didn't go to Oxbridge, and I'm from Scotland, as you can possibly tell from my accent. I wondered how well I would fit in with life at the bar in London. But in hindsight, again, I really needn't have worried about this. Three Hare Court's extremely welcoming, and members are very approachable. And I know Nick mentioned on some of the social events and things, but one of the other things that I find particularly useful is that we have some fantastic WhatsApp groups where you can send any queries or issues that you're having. And there's chambers-wide WhatsApp groups, but also groups limited really just to the very baby end of the juniors, so the most junior 6 or so pupils and tenants. And to me, this chat in particular was and still is a bit of a lifesaver, because any queries that you might not otherwise want to go out to the wider chambers groups that everyone sees can be contained in these smaller chats and just sent to a group of people who are doing the exact same things that you're doing day in, day out, and have most recently kind of been in your shoes. But it means that if you have any last minute queries that arise even when you're at court, you can drop a message onto this and people will tend to respond fairly immediately if they can, or if they've had experiences similar to what you're asking about. All this to say that you really get the sense at Three Hare Court that everyone wants each other to succeed. And that's a really nice feeling at what can otherwise be quite a cutthroat profession. But you certainly feel very encouraged, and there's also lots of laughs to be had at chambers. So I really would encourage anyone who's considering to apply for pupillage here. I'll now pass you on to Adam, who will talk a bit more about tenancy and how to build your practice.
Thank you very much, Claire. I think I'll begin by just echoing everything that Nick, Anna and Claire have said, and my contribution today is to focus on what life as a tenant looks like when you're roughly 1 year in. So as Nick, Anna and Claire have mentioned, there's more or less a continuum to your development. You start off as a first 6 pupil, you get to grips with the basics of written advocacy and written advisory work, shadowing your supervisor in conferences at court, and you gradually, over time, from the very beginning of your pupillage onwards, you learn the basics of how to deal with lay clients, how to deal with your professional clients, how to deal with opposing counsel, and how ultimately to conduct yourself in the courtroom and as a barrister. And so once you have reached the point where you're roughly 1 year in, you will have spent that post-pupillage year consolidating those skills and building a foundation on which you can build a practice that is really and truly your own. It's been touched on by previous speakers that one of the best things, in my view, about Three Hare Court is the flexibility and the variety of work that comes into chambers, because it's because of that you essentially have the building blocks with which to construct your own practice, a practice that really is yours going forward. And that's what 1 year into tenancy you can realistically start to think about, because as I say, you've mastered the basics of advocacy and advisory work by that point in time. You've appeared in cases on the small claims track, on the fast track, and on the multi-track. And you've done so in a variety of different contexts and in a variety of cases ranging from the fairly straightforward to the fairly difficult. And one thing to emphasize in relation to that is development is something that occurs during this process and will continue as you develop. You'll find that because you're not stuck on a one-way ticket, or because you're not confined to one practice area, you will find that you really are always learning. And the nice thing about Free Hare Court is as well, is that you're not doing so in a vacuum. Because of the collegiate atmosphere in Chambers, you really can reach out to pretty much anyone. I think that I know I definitely have. If I've ever had a query about anything big or small, and I'm not quite sure, or it's something I've not come across myself, I know that there are so many people that I can just pick up the phone and they'll be there in a flash to help me over it. And once I've done that and I've learned that, then I can pass that knowledge on to the tenants and pupils who are coming behind me. So as I say, once you're 1 year in, you're really looking at thinking about how you can develop a practice that's truly yours. You'll have developed an understanding about which areas you're particularly interested in, and you'll have mastered the art of, you'll have built up a network of relationships with solicitors as well. So you're perfectly positioned to do just that. And what tends to occur as well is that the longer you're in Chambers, you'll find that as a junior, slowly opportunities to be led in more complex pieces of work will come your way. And that's something that will enable you to develop your skills by leaps and bounds. And also something that will enable you to specialize, because once you've been led in a particularly complex case, say either in High Court, the Court of Appeal, Privy Council, the Supreme Court, you're able to put yourself forward credibly as a candidate to solicitors who work in specialist areas of practice, because you'll say, I've appeared in X case, which considered perhaps the very foundations of this particular area of law. I'm well equipped to do the work that your firm specializes in. And so you can present yourself in that way and develop your practice accordingly. I know for my part, one of the things I've most enjoyed is that I've, at a very early stage in my career, had the opportunity to be led in a number of, well, it sounds like I'm tooting my own horn here, but I would say really quite important and interesting cases arising from the Commonwealth Caribbean before the Privy Council in some really, really fascinating areas of public and constitutional law. And so I'm just looking forward to seeing where my practice goes to next and trying to develop it accordingly. But that's really what life as a tenant with, just over 1 year looks like. And so I think I'll hand back over to Tom at that point.
Thank you. Yeah, well, thank you, Adam. Thank you, Nick. Thank you, Anna. Thank you, Claire. I didn't know in advance what anyone was going to say, so I'm rather relieved that it was all relatively positive. So that's good news. I know we're probably bang on 7 o'clock now, but I'll ask you to just bear with us perhaps for another 5-10 minutes so that we can answer some of the questions that have been pre-submitted and some of the questions that have been asked whilst we've been talking. But perhaps because of time constraints, I will ask anyone answering a question to use their best advocacy and keep it short and sweet and just make your best points. So this is some of the pre-submitted questions. What steps has Chambers taken in terms of supporting pupils' well-being? Well, perhaps if I kick off and answer that one. I mean, it's fair to say we've all been there. We all understand that pupillage can at times be stressful. So as well as the support network that is provided by the supervisors in Chambers, we have a mentoring scheme in place for pupils, whereby each year an experienced pupil supervisor steps outside the pupil training programme and is available for pupils to speak to on an entirely confidential basis. So that enables pupils to speak freely about any problems or issues they may be having so that they can be resolved hopefully as swiftly as possible. And in addition to that, what I would say is my door is always open, as too is Chloe's. We're always just an email or a call away if one of our pupils wants someone to speak to other than their supervisor. Next, someone is asking whether members of Chambers, in particular pupils, junior tenants, are encouraged to undertake pro bono work. Perhaps Adam, you can briefly answer this one.
Yes, so I'll be quick. The short answer is yes. For my part, I'm very interested in employment law, and I've undertaken lots of pro bono work in that particular area of practice. And so I've done some work for Advocate before the Employment Tribunal, and I've also appeared before the Employment Appeal Tribunal as well on behalf of North Kensington Law Centre. So absolutely, the answer is yes. And you just have to go out there, find opportunities you want to do. Advocate often advertise for pro bono assistance on a variety of cases, and entirely you can do it all off your own bat, and Chambers will support you.
Yep, absolutely. I think the message is the more advocacy you can get under your belt, the better. Do members of Chambers have opportunities to review their practice with the clerks? Well, I think I touched on that with practice reviews, but perhaps Anna, you can just briefly talk to this.
Yes, so very briefly, you have quarterly practice reviews with your clerks, and so as part of this, you discuss, the levels of work, the type of work, the amount of advocacy you're getting, what upcoming work you have, any recent or upcoming client contacts and relationships you're building, general marketing, how you're going from a financial perspective in terms of, what work have you done, how much has been paid, what hasn't, how you're feeling within yourself, and then also a kind of agreed action plan for the next 4 months. So it really just allows you to build your practice and to actually incrementally reflect on what's happened the last 4 months and get better. So I won't say anything more than that, other than yes, there's certainly that opportunity.
Great, thank you. What is Chambers' maternity policy, or probably we should say parental leave policy? Chloe, in a couple of sentences.
Oh, that's a challenge. Yes, no, we have just recently or relatively recently updated our parental leave policy, and it's quite a detailed document, but the headline points are that members are entitled to take parental leave of up to 12 months, which may be extended upon application. And during that period, you are relieved of having to pay any Chambers rent, and that includes common parts. And you also are entitled to a reduction in the amount of your contribution to Chambers expenses. If you take a period of parental leave of 3 months or longer, you can take out an interest-free loan upon return to Chambers, and Chambers will also be particularly proactive in terms of assisting you with marketing upon your return. So you will receive some funding from Chambers if you ask for it to organise a marketing event when you return from parental leave. And the clerk's room will assist you more generally in terms of targeted marketing when you return, for example, publishing your return on the Chambers website and contacting solicitors to update them as to your status and that you've returned to practice. And the final headline point is that we have what we call KIT days, or keeping in touch days. So those are days normally towards the end of your parental leave, where the senior clerk will have generally virtual meetings with you to discuss your return to practice and what training you might want to have, or it can just be sort of a practice review type meeting, and it's designed to make the transition from parental leave back to practice as smooth as possible. And members are kept updated throughout parental leave of important Chambers meetings, marketing events, and other social events, seminars and conferences. So you're very much not isolated, even if you choose to take a parental leave of up to 12 months.
Fantastic, thank you, Chloe. Can you share your top tips for the panel interview stage of the application process? Well, Nick, as you've already given us top tips of making an application on paper, perhaps your top tips for interviews.
Sure, Tom. I'll try and keep this as brief as possible. I'll go with 5 top tips as before: 2 for the first round interview, 2 for the second round interview, and then one for both interviews. So as quick as possible. First round interview, you should certainly revisit your application form. It sounds blindingly obvious, but absolutely familiarize yourself with the details of that application form, because you will certainly be asked questions about it. The second top tip is make sure you prepare good answers to questions like why 3-hair court. Very important questions, and it's important you have tangible answers supported by evidence as to why you're applying, why you want to start your career here. In terms of the second round, I recommend practicing topical debate questions about issues in the law. It came up in my second round along with my co-pupil Rory. We had an interesting debate question to answer, and then we were asked to argue the complete opposite side. So practice arguing both sides to topical debates. Fourthly, in terms of the advocacy exercise, my advice would be, given the time constraints, focus on your key submissions and actually narrow down the number of submissions you're planning to make. You should also be prepared to start with your first submission, but perhaps be asked to move to your final submission first. That can happen. A panel can intervene and ask you to take your third submission first or your second submission first. So be prepared, but with that, make sure all of your submissions are meritorious and clear. And then finally, for both interviews, again, an obvious piece of advice, but consciously slow yourself down. I recall being nervous. It's very normal to feel nerves during an interview setting. But if you consciously slow yourself down, you speak slower, you'll communicate and impart what you have to say more effectively to the panel. So those are my top tips. Back to you, Tom.
Nick, thank you very much. And looking at the clock, we're now at sort of 8 minutes past 7. So I don't want to sort of undo all the potentially good work we've done by annoying people by overrunning. So I think what I will say is, if we haven't answered any questions that you have, do email us. And as I promised, the dedicated pupillage email address is sort of on that slide. And we will do our best to come back to you, or we will come back to you and answer any questions that you have got that we haven't had time. So I think that really just calls me to say thank you, everyone that has contributed, but most of all, thank you for joining us on a rather sort of cold and dark Thursday evening. I hope some of what has been said has been informative, possibly even interesting. If you take anything away from this evening, you should remember that every member of Chambers that you've heard from this evening has been through the process that you're about to embark upon, and they've all come through the other side. Whilst it might seem daunting and also at times a little overwhelming, hopefully some of what you've heard from us will have addressed some of the unknowns and some of the concerns you might have had. And whilst at times it's going to be challenging, I would urge all of you, embrace the challenge, do your best, and even try and enjoy the ride. And hopefully we'll see some of you at interviews in March. So thank you all very much and good evening.